These norms and standards, ladies and gentlemen, seek to enhance access to quality justice for all, affirm the dignity of all users of the court system, and ensure the effective, efficient, and expeditious adjudication and resolution of all disputes through the courts where applicable. Ladies and gentlemen, in keeping with the constitutional principles of accountability and transparency, this annual judiciary report provides the public with information on the performance of the judicial function by the judiciary in order to ensure transparency and underscore the judiciary's commitment to account to the public. The purpose of the Judiciary Day and the annual judicial report, therefore, is to explain to the nation how we have served them in the recent past, what challenges we confront, and how we seek to address them, barring those that are incapable of being resolved only by the judiciary without meaningful intervention by other arms of the state or the cooperation of other institutions within the broader judicial system. The annual judicial report that the Honorable Chief Justice Zondo will present today provides an overview of the performance of the courts. Distinguished guests, I take this opportunity to remind our stakeholders present today that this is an interactive session. I wish to express, on behalf of the judiciary, our most sincere wish that the engagements from the interactive session to be facilitated by Judge President C.M. Musi will positively contribute to enhancing the independence, impartiality, dignity, accessibility, and effectiveness of the courts. In conclusion, ladies and gentlemen, the hosting of the Judiciary Day accentuates the judiciary's commitment to maintaining the public's trust and confidence. That commitment is foundational in a democratic system based on a separation of powers among co-equal arms of state. We trust that our 2022-23 annual judiciary report will be well received by the South African public. Thank you for listening.
I just want to correct one small issue that I should have dealt with. When I invited the Deputy Chief Justice, I should also have referred to her as Bungane Mahadebe. And when I invited Deputy President Zondi, I should have said Nondaba. I now take the opportunity to invite the Chief Justice of the Republic of South Africa, Raymond Mnyamezeli Mlungisi Zondo Sohlaza. Thank you.
Thank you very much, Program Director, Judge President Dunstan Mlambo, and I'm going to retaliate and say Mapisa. Before I begin, I think I should highlight, even before I begin my address, the fact that we have a new Minister of Justice and Constitutional Development after the elections, Minister Simelane, and we have a new Deputy Minister of Justice and Constitutional Development, Deputy Minister Andries Nel. And I thought that I must just particularly welcome them before we go further. But I thought also, before I go further, I must take this opportunity to congratulate Justice Mandisa Maya, our Deputy Chief Justice, on her appointment as Chief Justice of the Republic of South Africa with effect from 1 September 2024. I think all of us know how historic this appointment is. And I thought that before I start, I should express my congratulations and also express my appreciation for the support that she has given me over the past 2 years since her appointment as Deputy Chief Justice. And of course, now she is Chief Justice Designate. Chief Justice Designate, Justice Mandisa Maya, Justices of the Constitutional Court, President of the Supreme Court of Appeal, Justice Molemela, and all Justices of the Supreme Court of Appeal, Judges President, Deputy Judges President and Judges, Regional Court President, Chief Magistrates and Senior Magistrates present, and all other members of the judiciary present here today, and all those who are following these proceedings online. Honorable Minister of Justice and Constitutional Development, Minister Simelane, Honorable Deputy Minister of Justice and Constitutional Development, Deputy Minister Andries Nel, Honorable Xola Ngola, Chairperson of the Portfolio Committee on Justice and Constitutional Development, and other members of the Portfolio Committee who are with us today. Commissioners of the Judicial Service Commission present, members of the Council of the South African Judicial Education Institute present, Advocate Shamila Batoi, National Director of Public Prosecutions, members of the Audit and Risk Committee, members of the Legal Fraternity, Ms. Sejosengwe, Secretary General of the Office of the Chief Justice, and all OCGO officials present here today and joining us online, heads and representatives of the national departments, state institutions, and members of the National Efficiency Enhancement Committee, members of the media present here, members of the public who are following these proceedings virtually, ladies and gentlemen, it gives me great pleasure, and I regard it as a special honor and privilege to stand before you today in order to present the Judiciary's annual report in respect of the year 2022 to 2023. Judiciary Day is an important annual occasion on the calendar of the South African judiciary. It is on Judiciary Day that through the Chief Justice as the head of the judiciary of South Africa accounts to the people of South Africa for the performance of their functions. Section 55(2)(a) and B of the Constitution places an obligation on the National Assembly to provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it and to maintain oversight of the exercise of national executive authority, including the implementation of legislation, and also to maintain oversight of any organ of state. Section 92 of the Constitution deals with the accountability and responsiveness of the President and his or her ministers for the exercise of executive functions entrusted to them. Section 92(2) provides that members of the Cabinet, which includes the President but excludes deputy ministers, are accountable collectively and individually to Parliament for the exercise of their power and the performance of their functions. Section 92(3) requires members of the Cabinet to act in accordance with the Constitution and to provide Parliament with full and regular reports concerning matters under their control. Section 93(2) ensures that deputy ministers are also accountable to Parliament for the exercise of their power and the performance of their functions. There are no similar provisions in the Constitution in respect of the accountability of the judiciary to Parliament or the executive in respect of the performance of the judicial functions of the judiciary. This does not mean that the judiciary does not need to account for the performance of its judicial functions. Indeed, we take section 1652, read with subsection 6 of the Constitution, as providing the constitutional basis for Judiciary Day and for our annual judiciary reports through which we account to the public of South Africa for the performance of our judicial functions. Section 1652 of the Constitution provides, and I quote, "The courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear or favor or prejudice." Section 1656 of the Constitution places upon the Chief Justice, as the head of the judiciary, the responsibility for the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts. In respect of the superior courts, the Chief Justice exercises this responsibility with the assistance and support of the heads of court, which are the President of the Supreme Court of Appeal and the judges president of the various provincial divisions of the High Court and of the specialist superior courts. In respect of the lower courts, the Chief Justice exercises this responsibility with the assistance and support of the judges president of the various provinces, the regional court presidents, the chief magistrates, and other members of the leadership of the regional and district courts. Therefore, the holding of Judiciary Day and the presentation of the 6th Annual Judicial Report are the results of collaboration and cooperation among various structures within the judiciary and the support from the leadership of the Office of the Chief Justice and other officials at the OCJ. The holding of annual judiciary days and the release to the public of annual judiciary reports constitutes irrefutable evidence that the judiciary unequivocally and unconditionally embraces the notion that it must account for the exercise of its judicial functions. We must account to the public for the performance of our judicial functions. After all, the positions that we hold as members of the judiciary, we hold because the public adopted a constitution which makes provision for us to hold these positions. Indeed, I want to go further and say the public is central to our constitutional democracy. I remember that in 2017, when I was interviewed for the position of Deputy Chief Justice, one of the commissioners of the JSC asked me the question, what is the significance of the first 3 words in our Constitution? You remember the first 3 words of our Constitution? Everybody? We, the people. The first 3 words of our Constitution are we, the people. So he asked me what the significance was of those 3 words. My answer was that those 3 words at the beginning of our Constitution denote the centrality of our people to the constitutional order that was introduced by this Constitution. If I was asked the same question today, I would give the same answer because it is the correct answer. It goes to the centrality of the people. And yet so often, some of the people who are supposed to serve the people, some of the people who hold positions in our constitutional democracy, who are supposed to put the people first in whatever they do not do so. They only remember selectively that the people are central to our constitutional democracy. What is the scope of the performance of judicial functions covered by the Annual Judiciary Report? The scope of the Annual Judiciary Report that I'm presenting today, like its predecessors, covers only the following matters within the judiciary's performance of its judicial functions. A, matters finalized by each superior court, assessed against the target fixed in relation to each superior court. B, delivery of reserve judgments against targets set for delivery of reserve judgments. C, the reduction of criminal backlogs. And whereas in the past, or in some of the years, we did not include the lower courts. In this year's report, we do have information on the performance of the lower courts, even though it is not adequate. There is still quite some work to be done for us to get to a point where we are able to report properly, accurately, and adequately on the performance of judicial functions by the lower courts. The first two features of the scope of the report apply to all courts, whereas the last one applies to criminal courts at high court level as well as in the magistrate's court. I will deal later with other features of the assessment of the judiciary's performance of its judicial functions, which do not fall within the scope of the annual judicial report, but which are nevertheless important. For now, it is appropriate to share with you some of the important information in the report concerning the judiciary's performance of its judicial functions. Court performance. The sixth annual judiciary report provides an overall picture on how the superior courts and the lower courts have performed their judicial functions during the period under review. The annual judiciary performance plan indicators for the judiciary as reflected in the annual judiciary report 2021-2022 remain relevant for this reporting period. The AJPP, namely Annual Judiciary Performance Plan, defines and identifies performance indicators and targets for the various courts. The performance indicators and targets are measures that allow for the monitoring of performance on one or more aspects of the overall functions and mandate of the judiciary. Performance of the superior courts. For the period under review, 11 or 13 performance targets were fixed by the judiciary to be achieved. Of these 13 targets that were fixed by the judiciary for their performance, 11 have been achieved. This represents an 85% achievement. Only 2 performance targets were not achieved. Those relate to the percentage of finalized constitutional court cases, which was 55%, in circumstances where the target that had been fixed for this period, as had been the case for the previous years, was 70%. And the percentage to which criminal case backlogs was reduced. The target that the judiciary had fixed for all superior courts in respect of target was that backlogs should be reduced to at least 30%. Taking all the superior courts, we were not able to achieve that target. We were only able to reduce backlog up to the average of 47%, which means that this will have to be work in progress, and hopefully in the next annual report, we will perform better. We are frank with you, the people of South Africa. We tell you where we have not performed the way we should have. We tell you where we have performed well. We think you are entitled to know because you pay our salaries. We do not think you should not know how we perform our duties. And we will not hide our performance from you. All the superior courts fixed targets for matters that they would finalize during the period under review. That is the 2022-2023 financial year. That means the period 1 April 2022 to 31 March 2023. The targets that the superior courts fixed for themselves and what they achieved or failed to achieve are reflected as follows in respect of all the superior courts. The Constitutional Court had fixed 70%, but it only achieved 55%. The Supreme Court of Appeal had fixed in respect of appeals 80%, and it achieved 85%. In respect of applications, the Supreme Court of Appeal had fixed 80%, and it achieved 91%. The Labor Appeal Court, in respect of appeals, had fixed 80%, and it achieved 96%. In respect of applications or petitions for leave to appeal, the Labor Appeal Court had fixed 90%, but it achieved 100%. In respect of criminal matters finalized in all divisions of the High Court had fixed 75%, and they achieved 83%. In respect of civil matters finalized in all divisions of the High Court, the divisions of the High Court had fixed 64%, but they achieved 85%. In respect of matters in the Labor Court had fixed 58% as their target, and they achieved 58%. In respect of matters in the Electoral Court had fixed 90% as their target. They achieved 100%. In respect of matters finalized by the Competition Appeal Court, that court had fixed 85%, but it achieved 88%. The Land Claims Court had fixed 60% as their target. They achieved 72%. It will be seen from this that the overwhelming majority of the superior courts performed excellently. They either reached their targets or exceeded their targets. It will also be noted that although the courts fixed their own targets, generally speaking, they fixed very high targets for themselves. Quite often, it was 70%, and above, and they mostly achieved the targets and in a number of cases exceeded them. The Constitutional Court did not achieve its target of 70%, but went up to 55%. Previously, it had done better than 55%. And this issue is being investigated to establish exactly why there was such a big drop. But 55% is, of course, not a failure. It's simply not as good a pass as one would have liked. And of course, in the judiciary, a pass is 50 and above, and not 30%. But of course, I may as well take this opportunity to remind everybody that the public is aware of the challenges that the Constitutional Court is facing, because the public continues to be informed of those challenges. The public will be aware that recently the Constitutional Court took the position that in order for it to properly discharge its obligations and perform in an acceptable way, it will be necessary for an amendment to be made to the Constitution so that it is able to dispose of a number of matters without every justice having to take part in every case. Because at the moment, the constitutional requirement that the justices of the Constitutional Court should sit and bank means that if there are 300 new applications that come in, every justice serving at the court at the time should take part in deciding all those 300 cases. Whereas if 300 new applications or petitions arrive at the Supreme Court of Appeal, because the Supreme Court of Appeal does not have the constitutional requirement that they must sit and bank, they are able to sit and dispose of those 300 new applications through panels of 2, which means that 12 panels or so are able to dispose of 300 new applications and share that responsibility among themselves, with the result that one justice will have sat in only a certain number of matters, whereas if those matters are dealt with in the Constitutional Court, every one of the 11 justices of the Constitutional Court has to be involved in those 300 matters, except where there's one reason or another, acceptable reason for them not to participate. So if the Constitutional Court is able, after a constitutional amendment has been made, to sit in panels in terms of disposing of applications, that will make a big difference. That does not necessarily mean that in terms of matters that get heard as appeals, the Constitutional Court would sit in panels. As things stand, we in the Constitutional Court take the view that as far as matters that would be heard are concerned, those matters would still be heard by the full panel. But a lot of other matters, applications would be disposed of without every justice of the Constitutional Court having to be involved. Of course, also, the public will be aware that we addressed the issue of resources in the Constitutional Court, and we have proposed to the executive that experienced lawyers be employed who would provide support to the justices of the Constitutional Court and therefore make their load lighter. We are going to wait to hear from the executive whether they go along with the idea of a constitutional amendment as well as giving us more resources. We have looked at many apex courts internationally and found that a lot of them get assistance from experienced lawyers in order for the justices of the apex courts to perform their duties properly. It will also have been seen above that there must be a lot of room for improvement in the performance of the labor court. It set for itself a low target of 58% and achieved it. It needs more posts for judges in order to cope with its workload. Indeed, it's been a few years that the labor court has approached the executive to ask for more posts of judges to be created, to ask for more courtrooms so that more cases can be done. I have been involved in that. That has not been coming as quickly as it should have. There is nothing judges can do if there are not enough judges and if there are not enough courtrooms. And in order for judges to have that, they depend on the executive. As I say, this is a matter which has been discussed with the executive, and they are the ones who must make decisions concerning the creation of more posts for judges. A reduction of criminal case backlogs. With regard to the reduction of criminal case backlogs, the various divisions of the High Court had fixed 30% as their target, to which they would reduce the backlog. However, collectively, they have failed to achieve this target and managed to only reduce the criminal case backlog to 47%. Here, they did not do well. On reserve judgments, as far as reserve judgments are concerned, collectively, the superior courts had fixed 70% as their target for the handing down of judgments that have been reserved during the period under review. They succeeded in handing down 72% of the judgments reserved during the period under review, thus doing very well and exceeding their target by 2%. During the period under review, the Supreme Court of Appeal completed 204 appeals out of a total of 239 appeals. This was 85% of the appeals. The SCA achieved 5% more than the target of 80% it had set for itself. The Supreme Court of Appeal finalized 1,266 applications or petitions out of a total caseload of 1,387 applications or petitions. This was a 91% achievement. This means that the SCA exceeded its set target of 80% by 11%. Compared to the previous year, the SCA managed to exceed the set target of 80% during both reporting periods by finalizing 1,266 applications and petitions, respectively. Specialized courts overview. During the period under review, the Labour Appeal Court finalized 24 appeals out of a total caseload of 25 appeals. This is an achievement of 96%. The LAC exceeded the annual target of 80% by 16%. The Labour Appeal Court also completed 126 petitions out of a total caseload of 126 petitions. This was 100% performance. This means that it exceeded its target of 90% by 10%. The Labour Court completed 2,034 matters out of a total of 3,512. This represents a 58% achievement. This means that it achieved the set annual target of 58%. It also represents a decline of 18% to its performance recorded for the previous reporting period. This period under review, 18% less Labour Court matters were received, whilst 21% less matters were finalized. The Labour Court sits mainly in 4 locations: Durban, Gqeberha, Cape Town, and Johannesburg. The caseload decreased in 3 centers, save for Durban, which increased by 7%. Matters finalized in the various Labour Court centers have decreased, particularly by 34% in Cape Town, 30% in Gqeberha, and 31% in Johannesburg. The Land Claims Court completed 144 matters out of a total of 199 matters. This represents a 72% target performance. This is an overachievement of 12% against the set annual target of 60% and an impressive improvement from the previous financial year. The Electoral Court only had 11 matters and it finalized all 11 of them. This represents 100% performance, which is an overachievement of 10% against the set annual target of 90%. The Competition Appeal Court finalized 15 matters out of a total of 17 matters. This represents 88% achievement. It represents an overachievement of 3% against the set annual target of 85%. The percentage of criminal case backlogs. The judiciary is committed to the reduction and ultimately elimination of backlogs in the various courts. The percentage to which criminal case backlogs reduced refers to the percentage to which it was intended to reduce the case backlogs during the period under review, and the percentage to which the case backlog was actually reduced. The annual target for all superior courts is set on 30% and mainly aims to ensure the finalization of criminal matters within 12 months from the date of the accused's first appearance in the High Court. At the end of the period under review, the total number of outstanding criminal matters in the various divisions of the High Court was 970, whereas the total number of backlog cases was 460, which represented a backlog of 47%. The performance during the reporting period, therefore, is an underachievement of 17% against the set target of 30%. Compared to the previous reporting period, the number of outstanding criminal trials increased to 19% compared to the 870 outstanding trials and 28% in the criminal case backlogs compared to the 353 reported criminal case backlog. The reason for this is ascribed to logistical challenges, mainly due to the continuous load shedding, which has stopped temporarily, which had an adverse impact on the operations of the courts. Compared to the previous reporting period, the number of outstanding criminal cases increased by 19% compared to the 917 outstanding cases and 2% in the number of criminal case backlogs compared to the 453 reported criminal case backlogs. This increase is also ascribed to logistical challenges, mainly due to the continuous load shedding, which had an adverse effect. It should be noted that in order to successfully attain the indicator on backlogs, the percentage of backlogs should be less than the annual target of 30%. The target was achieved in the Eastern Cape Local Division, in Bishop, Free State Division, Bloemfontein, Gauteng Local Division, Johannesburg, Gauteng Division, Johannesburg, Limpopo Division, Polokwane, and the Limpopo Division of the High Court. During the period under review, the various divisions of the High Court managed to finalize 9,715 criminal matters out of a total of 11,765 criminal matters, which represents 83%. The annual target of 75% was exceeded by 8%. Compared to the previous reporting period, a marginal increase of 6% is noted in the total number of criminal matters, 11,765, compared to the 11,098 reported during the previous year, whilst a decrease of 1% is noted in the total number of criminal matters finalized. From the above national overview, it is evident that the majority of the divisions of the High Court managed to achieve the set annual target of 75%, with the exception of the Eastern Cape Local Division, Mthatha, Eastern Cape Local Division, Gqeberha, Gauteng Division, Pretoria, Gauteng Local Division, Johannesburg, Gauteng Division, KwaZulu-Natal Local Division, Durban, Limpopo Local Division, Thohoyandou, Mpumalanga Division, Mbombela, Mpumalanga Local Division, Middelburg, Mpumalanga Division, Middelburg, and Northern Cape Division in Kimberley. The reason for this underperformance is ascribed again to logistical challenges and load shedding. The highest percentage was achieved by the Free State Division, Bloemfontein, 94%, and the Limpopo Division, Polokwane, 94%, followed by the Western Cape Division, Cape Town, 92%. The Gauteng Division achieved 57% performance, which represents 18% below the target of 75, and can mainly be ascribed to the complex nature of the cases that the courts have to deal with, coupled with the multiple accused persons involved in many of the cases. Percentage of civil matters finalized in all divisions of the High Courts. During the period under review, a total of 94,347 civil cases were finalized out of a total of 110,387 cases. This represents an 85% performance against the set annual target of 64%. This means that the target was exceeded by 21%. During the period under review, all divisions of the High Court achieved or exceeded the set annual target of 64%. Compared to the previous reporting period, a decrease of 9%, represented by 9,884 cases. Performance is noted in the total civil matters finalized. High percentages were maintained by all divisions of the High Court, with the Limpopo Local Division, Thohoyandou, achieving the highest percentage of 98%, followed by the Gauteng Local Division, Johannesburg, which achieved 94%. The Mpumalanga Division, Mbombela, 92%, and the Limpopo Division, 90%. reserve judgments. During the period under review, a total of 3,853 reserve judgments was delivered within 3 months from the date on which they were reserved. This was out of a total of 5,368 judgments delivered, which represents an achievement of 72%. The target of 70% was therefore exceeded by 2%. Compared to the previous year, the total number of reserve judgments delivered decreased by 3%, while the number of reserve judgments delivered within 3 months also decreased by 3%. The highest percentage in delivery of reserve judgments within 3 months is recorded in the Limpopo Division of the High Court, Polokwane, while the Constitutional Court achieved 18% in the delivery of reserve judgments within 3 months. As I've explained in the public before, the Constitutional Court delivered some of its judgments within 3 months and others after that. Indeed, it delivers some of its judgment after 6 months and sometimes even 8 months. This performance on the part of the Constitutional Court, I've said before, needs to be considered in the context of the manner in which the Constitutional Court operates. As I said last year, on this occasion again, when 11 judges sit to decide one matter, it's not going to be as easy as when one judge decides that matter. It's not going to be as easy as when 3 judges decide that matter. And indeed, it's not going to be as easy as when 5 judges decide that matter, because all of them must apply their mind and take a view, and all 11 must take a view, and also they mustn't rush to giving judgments, because that might lead to a situation where there are too many dissenting judgments. They need to continue to try and persuade one another with a view that when the discussions are completed, they are able, if possible, to produce one unanimous judgment, or if there are 2, there's a dissenting judgment, at least 2 or 3. But once they start producing 5 judgments in a matter, it becomes a difficulty. So there is an obligation on all the justices of the Constitutional Court, when they consider a matter and there are different views, to spend some time to try and find each other before judgment can be handed down. And when there are dissenting judgments, to try and see where the opinions differ and what it is that can be cut out. So it does take some time, but the support that we have said needs to be given in terms of human resources will go a long way, as well as the panels that we suggest should be allowed in terms of the Constitution. The regional courts, for the period under review, the regional courts utilized a combined total of 64,991 court days, a combined total of 189,164 court hours, a total of 37,280 new cases were registered, a total of 41,149 cases were disposed of by the regional courts. Let me mention that the manner in which the performance of the regional courts and district courts has been done up to now, is different from the manner in which the performance of the superior courts has been done. The district court and regional courts tend to look at the hours that the judicial officers spend in court, whereas in the superior courts, we don't look at that. We look at the outcome. How many cases have been finalized within a certain period? And that is mainly because, as far as the superior court is concerned, we all accept that we do not work from 8 to 5. Judges work all the time. They work in the night, they work over weekends, they don't work from 8 to 5. That does not mean that judicial officers in the regional courts and district courts do not work after hours and over weekends. I have no doubt that many do. But that just emphasizes why it's not necessary to be talking about how many hours we have spent in court. We must look at the outcome and acknowledge that judicial officers are not admin staff who come in at 8 and leave at 4, and then they will see work only the following day. They work beyond normal hours. The performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours 54 minutes. This is below the set norm and standard of 4 hours 30 minutes, but the combined hours for both criminal and civil matters adds up to 4 hours 42 minutes. Average clearance rate, 110%. Though most courts are able to keep up with incoming new cases, this is not the position in all regional courts, which indicates that additional courts are needed to deal with the increase in the workload. Finalized cases per day, 0.29. Cases disposed of per day, 0.63. Cases enrolled per day, 2.46. And cases in the regional courts seem to take much longer to finalize, which may be indicative of the increasing complexity of cases in the regional courts. A comparison between the current financial year and the previous financial year indicates that the court days increased by 2%. New cases decreased by 7% that were disposed of, or cases that were disposed of decreased by 5%, and the court hours increased by 10%. Regional Court Civil Performance Overview. For the period under review, the regional courts utilized a combined total of 13,477 court days and combined total of 27,252 hours, court hours, and 21 minutes. In respect of civil matters, the performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours, 1. This is below the set norm and standard of 4 hours, 30 minutes. It should be noted that many regional courts are doing both criminal and civil cases on a daily or weekly basis, with only a few regional courts doing civil cases only. Finalized civil applications per day, 1.09. Finalized civil trials per day, 3.6. A comparison of the current financial year with the previous financial year indicates that the court days increased by 14%, enrolled cases increased by 13%, finalized cases increased by 12%, and the court hours increased by 13%. Case flow blockages and challenges. A number of factors contribute towards case flow blockages, which entails the unavailability of stakeholders, the unavailability of courtrooms, defective court recording equipment and intermediary systems, load shedding, natural disasters, and bad and adverse weather conditions, among others. As far as reserved judgments and regional courts are concerned, regional courts do not reserve judgments for longer than 3 months. District courts, the collection and collation of the performance information of the magistrates' courts relies on the integrated case management system for the Department of Justice and Constitutional Development. On 15 August 2023, the heads of the administrative regions of the district courts resolved that as a result, inter alia of the ongoing challenges in the Department of Justice and Constitutional Development, the statistical information for criminal matters would be extracted from the magistrate's monthly judicial return submission. It highlighted that this statistical information is not a proper reflection of the judicial performance indicators for district courts based on the norms and standards. The Department of Justice and Constitutional Development disclaimed the data provided for domestic violence and harassment applications, as well as children's courts matters in their report dated 17 August 2023. They cite a variety of challenges which have given rise to the total number of cases and applications not being captured on the system, and that relates to the incompleteness of the statistics provided. The performance information in relation to child justice, preliminary inquiries, and maintenance matters is released as the completeness of the data is within the purview of the departmental annual performance plan. Indicators and readiness for audit by the Auditor General is established. The department received an unqualified audit and a performance of 80% for the 2022-2023 performance cycle. Average criminal cases finalized, 55%, that's in the district courts. Average child justice preliminary inquiries finalized within 30 days, 84%. Average percentage of maintenance matters finalized within a 90-day period, 89%. The Department of Justice and Constitutional Development has committed to rolling out fiber connections to all the courts to ensure stability on the ICT systems, and has indicated that there are plans to improve on a fresh new data capturing tool where the district court judiciary will be consulted. There is an improvement plan commitment to ensure that all statistics from 1 April 2023 to the current dates are complete and maintained thereafter through an initiative that will see supervisors and data capturers effect the days capturing before the end of each day. The high dependency on stakeholders within court environment has a negative impact on efficient case flow management. The respective district efficiency and enhancement committees and their provincial efficiency enhancement committees are the case flow structures that strive to improve stakeholder relations to address the blockages in the system to enhance court efficiency. And SAJ, in the period under review, the South African Judicial Education Institute conducted 136 courses, exceeding the planned target of 110. This success is attributed mainly to the technological innovation in virtual platforms. SAJ is the statutory institution that is mandated to provide training to those who are not yet judges or magistrates, but who aspire to be appointed as judges and magistrates in the near future, as well as the institution that provides ongoing judicial education to serving judges and magistrates. When this institution was conceptualized many years ago, it was envisaged that, as in a number of other countries, it should be led by a judge. But attempts to get it to be led by a judge at that time met with various challenges, which caused a considerable delay in SAJ beginning to operate. Ultimately, it was decided that it should, for the time being, be led by an administrator who would not be a judge, while attempts were made to resolve the challenges that at that stage stood in the way of the appointment of a judge as the head of the institute. Recently, the contract of the director or CEO of SAJ was due to expire, and this gave rise to the council revisiting the issue of this institute being led by a judge, because that idea had not been abandoned. What had happened was simply that the council and the leadership of the judiciary had been realistic. It had decided to be realistic in order to ensure that SAJA would start carrying out its mandate, and decided that the SAJA would in the meantime be run by an administrator. The revival of the topic of a judge as the head of the institute met with approval by members of SAJA Council recently. And an amendment to the SAJA Act was drafted by the Department of Justice and Constitutional Development, which would ensure that the institute was led by a judge, but that there would be an administrative head to be responsible for PFMA issues and other administrative matters that would not normally be appropriate to be handled by a judge. In this regard, I wish to express my and the SAJA Council's gratitude and appreciation for the determination, passion, and energy displayed by the former Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, in pursuing the amendment to the SAJA Act to accommodate the idea that the head of the institute should be a judge. I have no doubt that the new minister and Deputy Minister of Justice and Constitutional Development will work with the SAJA Council and the Judiciary in pursuing the passing of the Amendment Act to the SAJA Act. In this regard, I've noted that the new Deputy Minister, Mr. Andrew Snell, is not new to SAJA affairs, because previously he served as Deputy Minister of Justice and Constitutional Development and served on the SAJA Council. I have no doubt that his experience of some of the issues that were handled many years ago will be of great assistance to the Council as it tackles the issue of putting finality to the idea that this institute must be headed by a judge. I have no doubt that before the end of this year, or I hope at least, the amendment will be effected, will be passed. At this stage then, distinguished guests, I wish to simply say with regard to SAJA that the director who has served SAJA for about 10 years will soon be leaving. She has agreed to stay on while we look for another director, and this is the right time for me to say we are grateful to her, Dr. G, for your service over so many years. For your service for over so many years, and for your efforts in putting SAJA where it is. For over the years, it has trained so many judicial officers. I also must thank you for availing yourself to just stay until we have got your successor. But I also take this opportunity to thank the Secretary General of the Office of the Chief Justice for her support and cooperation on matters relating to SAJA as well. For SAJA and OCJ have been working together. Let me, before I conclude, take this opportunity to also thank Jade, the committee led by the Deputy Chief Justice that organized this function. Chief Justice Designate and your team, thank you very much for a job well done. But I also thank the SG and her team, the OCJ team, and there are a number of them here, for the hard work you have put into this project to make sure that today we would have a successful Judiciary Day. Thank you very much. As it was indicated by the Chief Justice Designate, that this is my last Judiciary Day, I want to take this opportunity to thank the Deputy Chief Justice, to thank all my colleagues on the Constitutional Court for their support and for their cooperation. I also want to take this opportunity to thank all the heads of court for their support, for their cooperation. I want to thank the regional court presidents for their support and cooperation, the chief magistrates, and all other judicial officers in the leadership in the lower judiciary for their support during the time that I've been here and on the judiciary days on which I've presented the annual judiciary report. I therefore officially make this annual judiciary report available to the public. Thank you very much.
Thank you very much, Chief Justice. We thank you for being so elaborate to ensure that you leave no stone unturned. You know, when I grew up, my grandfather used to tell me that the success of an event is measured by something that happens. I'm fortified that this day is very successful, and all because 2 glasses broke down. That to me tells you this is a successful event. I will now invite Judge President Musi to take the podium and direct proceedings on the question and answer session that follows now. JP Musi.
Thank you, Judge President Mlambo. Distinguished guests, protocol has already been observed. In the interest of time, I will stand by that protocol. Good morning. I am Kegni Musi. I am the Judge President of the Free State Division of the High Court. As already indicated, this is the time for question and answer session. It's now your time to calibrate the report that has been presented and gauge the depth thereof. The Chief Justice has, in his presentation, already anticipated a lot of questions and already answered some, but do not be put off by that. Just in terms of ground rules, there will be roving mics. When you request the mic and you are given the mic, please introduce yourself. Avoid long preambles before you ask the question. Preferably 1 question per person. We will have tranches of questions. I think it would be manageable if we have 3 questions at a time. The floor is now open for questions. Thank you. One, 2, there. Shane. Thank you.
Thank you very much, Judge President. My name is Bonelo Nomvalo. I'm a member of Parliament. I come from the Portfolio Committee of Justice and Constitutional Development. I just prepared a couple of questions to the Chief Justice. The first question that I would like to ask is in relation to Section 174 of the Constitution. Insofar as Section 152, which you have spoken about, is concerned. Section 152 talks about the independence of the judiciary. Now, Section 174, in terms of the appointment of judges, says or gives powers to the president, who is the head of the executive, to appoint judges. Now, the question that I would like to ask is, does that not open a can of worms in terms of the erosion of the judiciary, of the independence of the judiciary? That is, does it not invite, insofar as the separation of powers is concerned, does it not invite encroachment of the executive to the judiciary? And then the second question that I would like to ask is that, as you bow out, Chief Justice, how do you deal with a narrative, with a widespread narrative that says you have been a captured judge, you've been a judge of politicians, and that was mostly triggered by the manner in which you handled the Zuma, the former president, the Zuma matter, which emanated from the state capture and ultimately landed here in the Constitutional Court. One would have a view that to deal with perceptions, you were supposed to recuse yourself from the onset when the application was made, that you were conflicted in the commission. And what made things worse is that them was taken directly to the Constitutional Court. I believe that the High Court had jurisdiction to deal with the matter. To avoid wrong perceptions on the judiciary, I think the matter could have been handled in a better way, but the manner in which the matter was handled created a perception that the judiciary is highly conflicted and to a greater extent can be used by politicians to settle political scores. And then the last question that I would like to ask relates to the decentralization of the High Court divisions. Do you think that you've done enough in terms of decentralizing the local divisions, the High Court local divisions, with a view of enhancing access to justice? I'll talk about in my province, for instance, which is very vast geographically, KZN. For a person of Nongoma to access the High Court, he will have to travel for about 400 kilometers. And bear in mind that we have a problem of small legal firms which are not financially capacitated enough, which cannot bear the disbursements in order for them to access those courts to represent their clients. And in my view, Chief Justice, I think that if we're serious about enhancing access to justice, the High Court, especially the local divisions, must be decentralized to districts. Each and every district must have a High Court local divisions. I mean, they've already started doing that in my province. I come from Zimkhulu, in a small town called Mzimkhulu. I think we come from the same area, Chief Justice. Next to our town, there is a town called Kokstedt. I think the building of a new High Court local division was in progress. I don't know how far are they with progress. So I'm saying, I think we can do much better in terms of decentralizing the High Court to districts to ensure that there is universal access to the justice system of South Africa. Thank you.
Thank you, Mr. Nomvalo.
Thank you very much, Jay. It's Cameron Dugmore, also a member of the National Assembly and serving on the Justice Portfolio Committee. I firstly want to thank the Chief Justice and the Judiciary for this report. I think it reflects, despite challenges, a huge amount of work and visible improvements that are there. And in particular, I think it would be correct for me to also not only acknowledge the role of the Chief Justice in general, but in particular the way he led the Zondo Commission and the fact that it made South Africa look at itself very directly and ask some important questions about what has gone wrong in our society and what we need to do. So I want to express that appreciation and also wish the designate Chief Justice all the best. But I've just got two quick questions. The one is, I think all of us share a concern that it was indicated to us that for the second year, there are no statistics in regard to the courts at a lower level. And there's been a reference to load shedding IT systems. And I would like not just to ask the Chief Justice, but any of the magistrates sitting here, if we want to make sure that the next time we come here and this report is presented, what needs to be done to actually make sure and what assistance is needed that that information about what's going on at the lower courts in terms of targets, backlogs, all other issues is actually there. So I would like anyone to answer that question or to make some proposals. And then the last issue, just a question about language. I didn't notice anything or hear anything in the report. Obviously, we will read the full report, but I just wanted to get a sense as to, in terms of access to justice, how the issue of translation in our courts is working, any concerns, any problems, and what may be, might be some of the solutions to make sure that when someone appears, as a witness, or that they are fully able to follow the proceedings and ensure that justice be done. Thank you.
Thank you, Mr. Dagmo. Chief Justice, there are currently 5 questions. I propose that you deal with them if possible.
Thank you very much, Program Director, Judge Mosi. The first question that was asked by the Honorable Member of Parliament, who was the first to ask questions, as I understood it, was whether the fact that the Constitution gives the power to appoint judges to the President doesn't erode the independence of the judiciary. I'm not sure to what extent the question is relevant for today, the performance of the courts. But it may well be that the Member of Parliament thinks that it may affect the performance of the courts. But the short answer is simply that the fact that the appointment of judges is made by the President does not and cannot erode the independence of the judiciary, because the independence of the judiciary that we talk about is the independence of the judiciary that is contemplated by the Constitution. And part of it is that, part of the Constitution is that it is the President who appoints judges. The second question was based on saying I'm a captured judge. Again, I think the question has no relevance to the report we are about today. I accept that, particularly for the work that I did as chairperson of the State Capture Commission, I made many enemies. and that some of them from time to time hurl insults at me, and some of them want to discredit me. But I believe that the majority of South Africans, as Mr. Dagmore indicated, know the truth and appreciate the work that I, together with all those who were involved in the commission, did. So I will not engage in a discussion whether I'm captured or not. The third question from the same member of parliament was whether I didn't think that what he called the decentralization of local divisions of the High Court would improve, as I understood his question, access to justice. I don't know what the decentralization of local divisions of the High Court means. I have no idea what the Member of Parliament has in mind. I've never heard that term. It may be that what he has in mind is a situation where there are circuit courts. So you have a division of the High Court, and then judges from time to time from that High Court go to outlying areas to do trials there. If that is what he was talking about, then I understand. And I can say that that is done all the time by the various divisions of the High Court, and the JPs see to it, and certainly it helps in access to justice. But I must also say, Honorable Member of Parliament, that when it comes to access to justice, to a very large extent, some of the things that need to be done in order to enhance access to justice depend on decisions that must be made by Parliament and the executive, and not by the judiciary. And monies that must be spent in order to build courts closer to the people, money that must be spent in order to build more courtrooms, money that must be found in order to create more posts for judges so that more judges would be available to do cases. To a very large extent, those decisions lie outside of the judiciary, which I maintain is wrong. But that is part of what we have been fighting for as the judiciary for many years, namely the institutional independence of the judiciary. We have been saying we want a judiciary-led court administration model for South Africa's judiciary. In 2013, I've said this in public, in 2013, the judiciary made available to the executive a report in which the judiciary set out what it envisaged as the model for the institutional independence of the judiciary and the court, the judiciary-led court administration model. The purpose of giving that to the executive was so that the executive could see what the proposals were and respond and engage with the judiciary. They stayed for 10 years without responding to the judiciary. They responded only about a year or a year and a half ago. It's a delay. We had a meeting with the president on the 13th of December, myself and the president, to discuss this issue. And that meeting went quite well. But we had agreed that there should be another meeting within a few months to take that further. And that meeting hasn't happened despite my reminding the President that we need to meet. Recently, I've written to the President and said, President, please, we need to finalize the issue of the institutional independence of the judiciary. At least we need to get to a point where there is a memorandum of understanding between the judiciary and the executive as to what needs to be done in order to reach that level of institutional independence that is acceptable. And I've said to the President, before I leave, please choose any 3 days that suit you, and I will make myself available, because I would like to make sure that before I leave, we've made progress. But also I said so because at the judges' conference in December, it became very clear when this issue was discussed that the judiciary's patience is running out, and that the judiciary is beginning to say the executive is not serious about this issue, and negotiations between the judiciary and the executive don't seem to be going anywhere. And the judiciary is aware that in other countries on the continent, other judiciaries have gone to court in order to force the executive to grant the judiciary institutional independence, and they've been successful. Uganda is one of them. Zambia is another one. We would like this matter to be resolved through discussion. And we would like the executive to make it a priority. And one of the things that I hope we will not be arguing about with the executive, and I say it because in the response that came from the executive last year, the executive opposed our idea that the court administration model must be a judiciary-led model. But that is what the executive approved in the National Development Plan. It's already there, it's been approved. So I'm hoping that when we get to discuss this, the executive will not take us back 10 years back and say, let's talk about whether the model should be a judiciary-led one or not, because they have approved that it should be a judiciary-led. I'm just mentioning this because the honorable member touched on the issue of access to justice, and to say, to a very large extent, as the judiciary, we depend on the executive in order to enhance access to justice. Mr. Dagmore, thank you very much for your remarks. They are much appreciated. As far as the information about the lower court is concerned, we are hoping that next year we will have full information that the Department of Justice will be able to play its role. As far as translation is concerned, I think there are challenges with regard to translation services in the courts, but on the whole, the courts are able to proceed. But there is a need to professionalize those services. So that's what I can say, but any one of the colleagues must feel free if they want to add to those. Maybe before I stop, let me mention something that I had planned to mention earlier on, that we have a very interesting feature with the recent appointments and announcements, because I see that from 1 September, the Chief Justice will be female, The Minister of Justice will be female. Of course, the head of the NPA is female. And the president of the SCA is also female. Thank you very much.
Thank you, Chief Justice. Any of the colleagues that want to comment on what the Chief Justice said, on the answer of the Chief Justice? None. Chief Justice, I propose you keep that mic with you there. Any further questions? Thank you, sir. Where is the other hand? That side. Sorry. Yeah.
Thank you very much, Program Director. My name is Gola Ngola. I am the chairperson of the Portfolio Committee on the Constitutional, on Justice and Constitutional Development. On behalf of the committee and the Parliament, we wish first, Jason, to wish you a rested retirement. You have worked very much and very hard to serve the people of South Africa. In different positions on the bench, we know that your experience and your dedication has contributed very much in ensuring the transformation of the justice system. We wish you very well, and we thank you and your family for having given the country your expertise and experience to ensure that you contribute positively to the transformation of the justice system. Also on behalf of the committee that I'm leading and Parliament, we wish as well to congratulate Justice Maya for her new appointment as the Chief Justice, effective from the 1st of September. But it is our belief that you are not appointed on the basis of being a female judge. Because we'll be degenerating the transformation agenda if we think that people must be appointed on the basis of the agenda, which is unnecessarily, unfortunately, not their choice. It comes a natural, it's a natural package that we don't bring in life. But it is our conviction as the committee that you have been appointed on the basis of your requisite skills, your experience, and your capabilities. That you have been on the bench for quite some time. You have played in different roles. Now, time has come for us to have a new Chief Justice. Now, fortunately, to the basket of our transformation agenda, it's a female. So it's an additional kind of a package. It's not the basis on which you were appointed. We wish you well. We commit as the Justice Committee that we are going to create solid relations with the judiciary to ensure that we dispense justice to our own people. We have previously been working close with the Chief Justice Mogoeng. We have had annual meetings on matters of mutual interest between the judiciary and the legislature. We have done that with Justice Zondo, and we commit to you as well that as Parliament we are going to ensure that we create that solid working relationship so as to ensure that we are able to dispense justice to our own people in the country. Of course, the matter that relates to building of many courts with facilities that are actually accessible to even people with disabilities and other relative categories has been discussed between ourselves as Parliament and the Executive. They have already came to the Portfolio Committee to present their annual performance plan. So we, as we're seated here, know that there are a number of costs the executive already has committed to build in the financial year 2024-2025. So we're going to make sure that we tighten our oversight role given by the Constitution to ensure that that work is actually done, so that we're able to give the judiciary the support it deserves, so that it is able to perform better in the performance targets that it did not meet as outlined by the Chief Justice. I wish, on behalf of the Portfolio Committee on Justice and Constitutional Development, to say thank you very much. We have taken the Judicial Annual Report, which is going to be a working document as the committee that is going to determine the focal areas that we're going to use in oversighting the executive. There is the minister and the deputy minister. Thank you very much, Program Director.
Thank you, Mr. Ngola.
Thank you very much. My name is Molapi Soviet Lakhanyan from the National Assembly. I'm a Parliament JSC designate. Thank you very much, Chief Justice, for the comprehensive report that has been presented here. And I will also want to wish you well in your retirement. But also to say to you that you will leave this office with a high moral rectitude. We do not have any doubt about it. And we must also thank the successive layers of the judiciary in this country for standing very firm and executing your responsibilities with unimpeachable integrity, especially in the recent years when the country was at the brink of collapse. You remained our pillar of hope, the hope of ordinary men and women who do not have a voice, who live miserable and vulnerable lives. Thank you so much for that. It has been very outstanding. Chief Justice, I don't know if I'm going to be relevant, whether this question belongs to yourselves or to the minister, but I think it's something that we need to report about, Minister. One is that the non-racial agenda in the country is regressing. And I do not know what is our complexion as the judiciary in terms of advancing the non-racial agenda. Number two is with regard to the inclusion of the segments of our population that are historically excluded. And I don't know where we report about it. I listened to the report. I thought I would hear the target being mentioned, whether it is met or it is not met. But the reality is that we must be seen chasing the goal of building a united South Africa, where people are appointed to positions on the basis of their abilities meritoriously. Black, white, colored, or Indian, let them be appointed. If they are capable, they have the appropriate skills. But such appointments must also be contextual, taken understanding that we have a history of a country, we have a history of divisions, we have a history of exclusion, we have a history of paternalism and herrenfolkism, which we have to deal with. So I don't know, Minister, Chief Justice, where we report our performance on the realization of such a transformation targets, and I hope one day in our reports, we can include that. Chief Justice designate. If I was in church, I was going to ask the ministers of religion to pray that we have the wisdom to serve the people of this country better. Good luck in your new responsibilities. You have the support of the South Africans who are looking for justice. Thank you so much.
Thank you, Mr. Lekhanyan. Regional Court President Nadala.
CJ and all protocol observed, I hope that I am not speaking out of 10. But maybe let me start by saying we wish you a very good and comfortable rest, whilst at the same time also welcoming our coming new from the box, Chief Justice designate and Chief Justice to be. But I wanted just to touch on one issue that was raised in case we live with a wrong perception. There is no management, even in the judiciary, that can properly perform its function, Honorable MP, if there is no statistical tool, no kind of measurement in terms of how you know what you are doing. As the regional court, we have had a stats tool for more than a decade. Not only is it a stats tool, but it also has got the accompanying roll collapse reports, which clearly direct and show in terms of the challenges that we have in our courts as the regional court, where the actual problems lie. That stats is freely available every quarter, and we circulate it to all stakeholders. Nobody is denied access to it. So therefore there is one. It might not necessarily be of a standard. If it is not, that can be shared in a platform like this. But in our view, it can. Secondly, I also want to say, when the report was made, there was a report on the average court hours, and the regional court was given the amount of court hours on the average that it seats. I want to make it very clear that in the norms and standards that we developed as the judiciary, I think it's paragraph 5.2.1, Roman figure 4. There is a provision that all trial courts should strive to sit no less than 4.5 hours. In other words, sitting hours in court. Because what we have identified, and even during those deliberations, was that we don't sit enough as a result of all these court challenges in court. And there is a lot of stakeholders that are involved. we did not have to say how much a magistrate, regional magistrate, has to be engaged in his or her work. It takes definitely the whole night. It takes the whole weekend. It takes the after hours, just like any other judicial officer we would expect him or her to do. But the 4.5 was to ensure that, because it is where then we have a direct interaction with the clients, whether it's in criminal or in civil, to say how much did we see it. And we agreed as all the layers of the judiciary that all the trial courts, not appeals and whatever, where one would be sitting as a judicial officer alone, but in trial courts where we engage with other people, there should be a standard and minimum that we put on to ensure that we are delivering to a particular standard.
Thank you, Mr. Ngadala. Chief Justice, any comments on the comments?
No, thank you. I won't take much of your time. There are a number of things or features of the work of judicial officers in the lower judiciary that may have been introduced in the past because of certain circumstances. And we may have to look again whether we must keep those. I am just concerned with a situation where members of the judiciary who are in the superior courts don't have to record, we said 2 hours, we said 4 hours. It's taken for granted, it's accepted that they will be sitting maximally. They will be sitting a lot. What is focused at is the outcome. How much difference are you making on the outcome of the backlog, on the backlog? How much are you reducing it? So, but we must look at all of those things. There was a reason why it was done, but we would like a situation. I certainly would like a situation where we demonstrate more trust on members of the judiciary in the lower courts, that they would be sitting just as members of the judiciary in the higher courts, in the superior courts. And then of course we look at the outcome, and the outcome would show that they are working quite well. But I think that it's true to say, before anything be changed, we look at why it was put in. Is it still serving that purpose? And whether there is a better way of dealing with things. Thank you.
Thank you, Chief Justice. Any other questions? I will limit honorable members to 1 minute with their comments. Well, the Minister, thank you, Honorable Minister.
Well,
you're not an honorable member for these purposes.
Of course.
More than 1 minute.
Of course. And honestly, a minute is just too long. But I just felt that is the executive. Now that members started deliberating, it shouldn't come across as if we do not want to wish the designate well, commit ourselves as well as the executive to ensure that the report and issues that have been raised beyond, we commit ourselves to working with them. But to Chief Justice to also say, Siyabonga, Baba Mnyamezi, I think in your name, the forebears saw quite a lot. Uzawunyamezela-ke, ukuya phambili. But I was told judges don't retire. So maybe I should say ngizawuphinde ngikubone. That's all what we wanted to say. Thank you very much. Good morning to everybody. Wasn't that a minute?
Yeah, no, it's under a minute. Thank you. Thank you, Minister. Any further questions or comments? I suppose there are none. Thank you very much. As I said, the Chief Justice anticipated most of the questions in his presentation. I understand why there aren't any questions. Thank you very much. Over to you, JP Mlambo.
Thank you very much, JP Musi, and to the questions and comments that were made to our report. We thank you. It is now the stage where I would invite the President of the Supreme Court of Appeal, Justice Molemela, to come and deliver the vote of thanks. Minna Tsipi.
Thank you very much, JP Mlambo, Program Director. Allow me, ladies and gentlemen, to stand on the protocol that has already been established in the interests of time. It was Cicero, a Roman philosopher, who said, and I quote, "Gratitude is not only the greatest of virtues, but the parent of all others," unquote. It is therefore an honor for me to stand before all of you today to extend a heartfelt vote of thanks on behalf of the judiciary. To thank you in particular for your presence at this significant event where we celebrate and reflect upon the judiciary's performance and achievements. I first and foremost take this opportunity to congratulate the Honorable Chief Justice of the Republic, Chief Justice Raymond Mnyamezeli Mlungisi Zondo Sohlaza, on his comprehensive presentation of the Annual Judiciary Report for the 2022-2023 financial year. Chief Justice, please accept our sincere appreciation for your insightful address. The candid manner in which you have spoken on the performance of the courts, the challenges the courts face, and the proposals being pursued to make the court system more efficient attest to your pragmatic leadership that continues to steer our institution towards excellence. Your vision and dedication are truly commendable. I, on behalf of the judiciary, thank you for your courageous leadership during your term of office as Chief Justice of the Republic of South Africa. Your contribution as the head of the judiciary in the preservation of an efficient court system has been enormous and will stand the judiciary in good stead in the year ahead. We wish you the very best in your remaining term and beyond. A big thank you to all the judicial officers for their hard work in executing the core function of the judiciary, which is adjudicating cases and delivering judgments. You are truly the heartbeat of the production team. Your hard work, dedication, and perseverance in the face of challenges are self-evident from the outstanding performance and achievements we celebrate today. In this regard, it is also appropriate to acknowledge the important role that has been played by the SAJE team in facilitating the training of judges in pursuit of excellence. I also thank all the heads of courts for their direction and support to all members of their respective courts in all processes leading up to this event and generally for their stewardship. We highly appreciate the role played by all the members of the Accountability Committee and all those who worked tirelessly behind the scenes to compile the judiciary report that was presented today. I also wish to extend a special message of appreciation to the Chief Justice Designate, Justice Mandisa Maya, not only for the role she has played in leading the Judicial Accountability Committee, but also for holding the fort as acting Chief Justice and making sure that we continue to put our shoulders to the wheel whenever the exigencies of the office required the Chief Justice to be in other jurisdictions during the period under review. Of course, Chief Justice Designate, the announcement of your appointment as a Chief Justice on the eve of this august occasion is a cherry on top. Congratulations are in order, CJ Designate. On behalf of everyone gathered here, I would also like to express a special word of thanks to the Justices of the Constitutional Court for welcoming us into their house and for their generous hospitality. I also thank the members of the executive and parliamentary arms of state for their efforts in striving to support the judiciary in compliance with the constitutional injunction set out in Section 165, subsection 4 of the Constitution. Your presence here today bodes well for the future. It attests to the interconnectedness of the three co-equal arms of state, and in my respectful view, constitutes a public show of committee that remains necessary, notwithstanding the need for a clear observance of the doctrine of separation of powers. Your presence here today in support of the judiciary as the third arm of the state is therefore highly appreciated, Minister. I further extend a word of gratitude to our internal and external stakeholders in the justice system with whom we constantly interact to ensure that justice is served. In particular, the collaboration with our stakeholders in the Provincial Efficiency Enhancement Committee, as well as the National Efficiency Enhancement Committee, has improved the efficiency of the courts and enhanced access to justice for all, thus affirming the dignity of all users of the court system. Your support and collaboration are highly appreciated. A word of thanks is also extended to the administrative arm of the judiciary, the Office of the Chief Justice, led by the Secretary General, Ms. Mem Mesijo Singwe, and members of her team. Your meticulous planning and execution have made this day a memorable one. We appreciate this. A word of gratitude also to all those who participated in the program, members of the JAC, my colleagues, JP Mlambo, JP Musi, and Deputy President Zondi, for the work well done. Last but not least, I also extend a word of gratitude to everyone present here today for honoring the invitation to be part of this occasion, taking the time off your busy schedules to be here with us for the presentation of our annual judiciary report serves as affirmation of your support for the vision of an accountable judicial system. The virtual attendance of those following these proceedings online is similarly appreciated. As we conclude today's program, let us go on and treasure the reigning spirit of excellence, collaboration, and continuous improvement that defines our judiciary. Thank you once again and have a wonderful day.
Thank you very much, Justice Malemela. This puts us at the end of the program for today. I also want to extend my thanks for cooperating with me in directing the program. What we're going to do now is I'm going to request all of you to rise as the judiciary procession leaves. But in keeping with African culture, please ensure that what we've prepared for you in the foyer does not go to waste. You've earned the right to enjoy by being here. So thank you very much. Let me just invite then people to stand and the Chief Justice and the Chief Justice Designate to lead us out. Thank you.